as you can hear, this is being recorded. We actually have a wonderful and quite large, I think there are over 300 people registered from around the world. We also have a very international audience in the room, including lawyers and students. So welcome everybody. My name is David Wilkins. I'm the faculty director at the Center on the Legal Profession. And it is my great pleasure to welcome you to this event on Law 2.0, Creating a Modernized Legal System. As we will hear, the genesis of this webinar and meeting is this incredible book that Ron Dolan, who I will introduce to you in a second, has written on legal informatics. It is already the most important book that's ever been written on this very important and emerging topic, and it brings together a host of authors from the academy, from practice, from legal technology, from different fields of knowledge to really talk about how law, oh, I'm not turned on, oh, there you go, sorry, Brian. So do you want me to start all over again? No. Can people hear me? It's being picked up in these microphones. Is there a way to mute it in the room? Sorry about that, guys. This is tech showing. We're not experts on technology, but we do have experts on technology who are here who are going to talk to us about this important topic. Here's how we're going to proceed. I'm going to first introduce Ron Dolan, who is a senior research fellow on the Center on the Legal Profession, got his start at Google, so he earned his technology stripes and with the best of them, but also went to law school and has a full 3-year JD degree from the University of Hastings Law School, and is probably the most knowledgeable person I know at the intersection of technology and law. Ron is going to talk a little bit about the book project, I'm sorry, product placement again, the book project, which is available to you at your Amazon and all other dealers, but more broadly about why he wrote the book and why he thinks this is such an important topic for law students, for lawyers, for academics, and for the public as a whole. I think one of the things Ron will emphasize is this is not just an insular topic for the legal profession or lawyers, but is really deeply important for the world. Ron will talk for a few minutes about the project, and then I will introduce our terrific panelists. I may be blocking Andy Perlman, the most handsome one on the group, so I'll try not to stand in front of him. And we will have a discussion around some of the big themes that Ron has raised both in the book and in his talk. But our goal really is to make this discussion as wide as we can. So for those of you who are in the room, you should feel free to put your hands up and I will call on you. But we also, for our online audience, please, where are they putting the
in the Zoom chat?
In the Zoom chat, put your questions, and Dana Walters, who's right there, you can't see off camera, will read them to me. That was the voice of Brian Fong, who's our executive and research director at the center. We have some of our fellows at the center here. Tatiana Santos keeps us all running on time. So speaking of running on time, Ron Dolan, please say a few words about this terrific project.
Okay, hi. Let's see, first I'll say is I've been doing this long enough to be able to do it in my sleep, which is good because due to flight changes and whatnot, I'm on 0 sleep right now. So if I go astray, please just
Sorry.
I'd also definitely want to point out that this field goes back many decades, as we say in the book, and we were able to bring some people who have worked on this for decades to write chapters for the book. So that's nice. I think what happened for me personally was just going to law school, coming out of engineering, and just kind of jaw-dropping shock at the way that law is taught, practiced, et cetera, the way data is handled, et cetera. And I have a talk that I often give called An Engineer's Journey Through the Legal System. And, a lot of that is, as an engineer comes in and is looking for a data-driven decision-making, ideally, that the way you measure performance would be what is your output per a certain amount of input. None of this translates to law. And what I was looking for was where are the modern tools? I don't see them. And asking the question why we don't have those, and then figuring out that you know, some stuff is done by proxy reputation, it's not done by the quality of the work. So if you're from Harvard, your work is really good, period. Of course, at Harvard, that might be true. So,
Facts are facts.
But you know, within law firms, when you have things like the business model of the billable hour or partnership model, et cetera, that can get in the way of incentivizing the type of behavior that leads to efficiency, where people are kind of protecting the guild. So you want to say, oh, well, everybody should have a lawyer. Like there's all these barriers to moving forward on efficiency, and we're not measuring quality typically as we might want to do. Like as a programmer, I want to know that the code is well written. I want to test the bugs. I want to have 2 pair of eyes on the code that's being developed. All of these practices that I was kind of used to, and the mindset that I was used to, I just didn't see happening in law, and I tried to figure out what the bottleneck was. And in the process of unraveling all of that, it's not just as simple as bringing somebody a new tool and saying, hey, that tool is really cool, you might want to use it. It's all of the things that you have to do to convince people, or recognizing that the barriers in the court system is different than the barriers for big law, which is different than the barriers for like legal aid and access to justice. So the book was just kind of a placeholder attempt to be able to, for example, teach legal technology, to be able to have like a reference place. I would never argue that that's the best description of any of the content in that book. But it's a place to go where you have it all in one place, and at least it gives you a jumping point where it kind of all comes together, and it is starting to be used for classes. So, you know, my hope is that legal informatics is this underpinning for the development of legal technology. It includes things like design work, because otherwise you're building a hammer looking for a nail, and that's not going to work. It includes the business models around efficiency. It includes academic underpinnings. So there's a lot of things in that book that are just trying to put context around how this should happen. Even standards development is not typically discussed as important in law school. So how's that?
That's perfect. I think you've given us a lot already to think about here. And again, I commend to you, it's a book that has an enormous breadth, because this is a subject that has enormous breadth, and we're very lucky to have an incredible panel that can help shine light on different aspects of it. So I'm just going to introduce them from, I guess it's now since I'm facing the camera, my right to your left, starting with Jason Boehmig, who is the CEO of Ironclad, which is an incredible kind of contract management, contract analytics company, which has now become one of the fastest growing and most successful companies in legal technology. And I'm going to ask him some questions about that. He once was a lawyer. We call them recovering lawyers. And maybe we'll ask him a little bit about what being a lawyer got him to become a tech entrepreneur. Next to him is Susan Hendrickson. We are really thrilled, has just joined us here at Harvard Law School as the new executive director of the Berkman Klein Center for Internet and Society. The students in the room and many others know it really is, I think, the premier academic center, certainly the first and the most influential in thinking about the role of technology in society. But she too is a recovering lawyer, just recently gotten her inoculation because she was just a few months ago a senior partner at sorry about that, at Arlen Porter, doing deals and transactions. So we're going to ask her a little bit about what she both saw as a practicing lawyer, but then also what she now hopes to do in her new capacity. And last, but certainly not least, is my dear friend Andy Perlman, who is the dean and professor of law at Suffolk University Law School, and has really been a leader in the ABA community and the bar more generally on issues of legal technology. He ran it was, what did we decide it was called? The Future of Legal Services Commission that was put together by the president of the ABA several years ago, and has been doing a variety of very innovative things at Suffolk around legal education and legal technology. So you can see we have an incredible group. Sue, I told you I was going to start with you because you really are in this transition phase coming from legal practice to the academy. And I wonder if you would just say a little bit about how you encountered legal technology as a practicing lawyer yourself, but also in other roles that you played importantly in the legal profession, not just at your law firm.
Sure, happy to. Thanks everybody for being here today. I'm really excited about this new post at Berkman Klein Center, but I did spend almost 3 decades in private practice leading a technology transactions practice. And so one of the things, I'll be a little bit of an evangelist for informatics, because it's not a question of kind of when this is coming. This is coming. It's not there yet. I spent running a tech practice without adequate tech tools and seeing what was happening in the landscape and knowing that this was there. And we're starting to see from the different providers and thought leaders in this ways that a legal profession, which is fundamentally inefficient in a lot of ways, can really optimize that behavior. But looking at it from the other side, beta testing is hard in the legal profession, and you need to think about the trade-offs with respect to that on quality and how we're going to manage that from a society perspective. So I saw this coming in big law when I was there, primarily, originally on kind of corporate management of the overall law firm, and then into the deal flow. You're starting to see, and I think as lawyers going into the profession now, you're going to be working a lot more with these tools because clients are saying, wow, the legal profession has gotten so expensive and I need to figure out how to manage these costs and balance the costs and benefits of this analysis. And so instead of having teams of people look at these documents, now these AI models might be able to do it for me, and figuring out how we can pull out the insights and learnings and do that in a way. And in sometimes it's better than what, everything has errors. And so sometimes it's better than having individuals do that all the time. Sometimes there are different types of trade-offs associated with it. It may not be able to analyze a complicated document in the same way. And so I think the challenges that the lawyers in the practice are facing is, where is that value-added layer that the minds that are in the legal profession should really be playing, and how can you do that? Because when you take this to the access to justice areas and others, and you look at how this plays out in the criminal justice system or something, and this goes to the Berkman Society stuff, we're looking at all of these issues of bias and equity and how AI models play out. And when you look at that, the criminal justice system makes it very clear that we can't have those kinds of errors coming through with respect to it. And so you need kind of both a combination of human and machine to figure out how to balance this. And I could talk about some of the others. I also am on the board of Human Rights First, and one of the things that I find exciting in this application is that we're building an innovation lab that's incubating new technologies in the AI machine learning space for application in civil society and in policing context and others, that can try to figure out how, when you're looking at it from the civil society perspective, you can use these tools in the legal profession as well to figure out how you can look at tons of footage from cameras that might be being used in police cases, and how you can provide a counter from what the actors in the justice world might not be able to do. And so it's just really interesting applications that we're starting to see. I still see it as really nascent but growing, but it's gonna come in this next 5-10 year period.
So Jason, you live in that nascent but growing world, and I wonder if you could talk a little bit about why you decided to start Ironclad, and kind of what Ironclad does and how it tries to answer some of the needs that Sue just talked about at that intersection between technology and law.
Yeah, of course. Well, great to be here today. Yeah, so everyone, I'm Jason. I'm the CEO and I'm one of the co-founders at a company called Ironclad. We talk about what we do as making digital business contracts. So if you think about this transition, like really the great transition of all of our lifetimes, it's this transition from the analog world to the digital world. And just like I was listening to Spotify on my walk over to the law school today, and that's a shift from the physical analog CD or record player, that David and I love, and has its own benefits, but that is the great shift. And so we sort of are excited at Ironclad about this concept of the business contract, which has been around for literally thousands of years. In fact, predates the legal profession itself. And making that a digital asset. So it's not a digital asset. If you think about, I'm sure everyone in this room has made a contract, think about how many browser tabs that you have used in that and how many approximations of the physical world you have used in that. You have a PDF, it's an approximation of a physical piece of paper. You have a scribble in a UI somewhere that's an approximation of signing a pen on that. But you don't have a digitally native contract. And one of the things that I think is incredibly exciting, I'll talk about why I started Ironclad in a moment, but one of the things that I think is really exciting about that for hopefully the folks in this room and on Zoom is that transition is really happening now. It's one thing to talk about the transition and predict the transition, but it is happening. I can speak from the ground. We will do 1 billion digitized business contracts for our customers this year. And that has grown exponentially over the past few years. So those digitized business contracts are the sort of foundation for a lot of the themes that we'll hear about today and a lot of the themes that are in Ron's book, because they are in a digitally native format. They can be analyzed. They can be moved and manipulated in a digital form. And so going back to the original question, the reason I started Ironclad is I feel like I had some insight into that from my practice. I was a corporate lawyer. I only practiced for 2 years, and I never thought that I would be a startup founder. I always knew I wanted my career to exist at the intersection of law and technology. But I thought that was being a lawyer and using law in my practice. And I was amazed at, and one of the things I think is so special about this program and this school and this institution, I was amazed at how useful it was to know just a little bit about coding and a little bit about technology. So it would have taken me several decades to become my firm's biggest expert on securities litigation. But within 2 years, I was the firm's expert on technology, or at least one of them. And what I realized that—
And you were at a technology firm. I mean, you were at Fenwick. Okay, so that's saying something.
But just being able to write some code in Visual Basic was just enough that any real programmer and Ron would laugh at. But it was enough to be actually really useful in my practice. And I thought that my role would be to bring technology to the firm, and I was astounded at the lack of understanding between technologists and lawyers. And I realized that even my rudimentary technology skills enabled me to create unique things, such as like a script that would just run some simple red lines. And about 2 years in, realized I wanted my career to be flip-flopped. Instead of law and technology, technology and law. And that led me to start Ironclad. I talked about the sort of digital contracting that we're building and how we think about that. But yeah, that's a little bit there.
Well, terrific. And Andy, if there's any institution that's more resistant to change than a law firm, guess what that is, right? And I've known you for a long time. You just be like a regular law professor like me, teaching regular stuff. Actually, you were always better than me. But the fact of the matter is, you really made an important pivot. And that was actually even before you became the dean. And now you've really, I think, done some of the most innovative things that are going on anywhere in legal education in the world are happening right here in Boston and Suffolk. And so if you could talk a little bit about why you made that pivot, and then talk a little bit about how you've tried to drive change in this most change-resistant part of the legal profession.
Change-resistant is a very apt description. Thank you, David, for the invitation to be here and the opportunity to talk a little bit about legal innovation and technology in the law school context. As David was suggesting, this is something that I've been really committed to for quite some time. My law school has had a concentration, which is like a law school major, in legal innovation and technology since 2014, which may not sound like a long time ago, but in this arena was pretty pathbreaking. And the idea behind it was to teach our students some new knowledge and skills that would put them in a better position to succeed in a rapidly changing legal marketplace, introducing them to concepts like legal project management and process improvement. Those concepts have been used in the business world for decades, but have not been used particularly well in the delivery of legal services. Introducing them to basic technology like automated document assembly, how easy it is to automate the creation of legal documents, and also giving them an awareness of how the legal industry is being transformed and how legal services can be delivered better, faster, and cheaper. To be clear, our goal was never to create coders and technologists. That wasn't the point. If you think about what law school is about and what many of you are learning, it's about issue spotting. When you take a torts class or a contracts class, it'd be nice if you become torts experts and contracts experts, but nobody's under any illusion that you will become that in law school. What you are learning is how to identify concepts in torts, concepts in contracts, concepts in constitutional law. And what we were trying to do by creating this program was a kind of issue spotting for legal innovation and technology, so that when our graduates were out in practice in any setting, small firm, large firm, in-house legal department, nonprofit sector, when they saw a legal service being delivered, they would be able to identify ways in which it could be done better, faster, and cheaper through innovative methods and tools. And that was what we started with. That was the intuition. And the students who have gone through this program have gotten into jobs that didn't exist 5 or 10 years ago. A legal innovation advisor, legal solutions architect, working for legal innovation consulting companies. But they've also gone into traditional employment, large firms and small firms, where they are able to bring this expertise. Going to Jason, your point and your story is a perfect example. There are not a lot of lawyers and law firms and legal employers who know much about this field. If you have just a little bit of knowledge, you can go a very long way and you will be quickly relied on as the resident expert on all things legal innovation. And that was one of the inspirations behind our program, and it's helped us in a lot of respects. I could also talk about the ways in which it's not only helping students, but also the public through access to justice and access to legal services. But I don't want to jump the gun if you have.
All right, we will come back to that. But Ron, I want to give you a chance to come back here on an important theme that underlies kind of both the opportunity, but also the challenge of everything we're talking about. And actually, each of the speakers have touched on this a little bit. Andy just said, better, faster, and cheaper. But a lot of times when people think about technology, what they're really thinking about is faster and cheaper. And that the challenge is, what's the quality gonna be? And Sue, you talked about that in terms of some of the resistance that clients sometimes have. I know I've had enough conversations with you, Jason, to know that when you're out there in the marketplace, that's one of the challenges people face. And that's an issue that, Ron, I know you thought deeply about and thought a lot about in ways that are talked about in the book. And so I wonder maybe if you put that issue out there and kind of think about how you think about it, and maybe we'll get our panelists to react to it in some different areas in their own respects.
So the major, there's a, what do I call it? It's an ecosystem of barriers. Because what's blocking the courts is different than what's blocking, as I said, like a large firm from developing innovation and technology. And the thing that busts through most of this is quality metrics. And we haven't really developed quality metrics in law very much, but it really does allow you to know, for example, if you're trying to help somebody with an access to justice problem, or look at something like LegalZoom, whether or not the documents that are being produced are of a sufficient quality that they're really helping people. It's also true that when law was so inefficient. So let's just run through e-discovery quickly.
Sure.
Just say that the history of that is, there were just too many documents. So you couldn't put people in a room. Even, I mean, it was a cash cow for law firms. They gave it up begrudgingly. But at the end of the day, as one CIO told me at a large firm, my client said they could pay for the discovery or they could pay for the litigation, but they couldn't afford to pay for both. And you had to do a change. And so now the modern e-discovery platform is cloud-based, it's very efficient, et cetera. But the objection that came up is, but it's not as good as doing it by hand, but nobody ever measured. So there's, in this case, we have specific metrics, precision and recall for e-discovery that are very helpful. And when you finally do the measurement for technology, it turns out there's some errors. But that's not the full story because you never measured when the humans were doing it alone. So then when you go back and measure when the humans do it, it turns out there's more errors. And this is a comparative because nothing is perfect. So what's interesting here from the engineering perspective where you have quality, cost, or time, how long it takes, normally we say pick any two from an engineer perspective. Doing some home construction and you're lucky if you get one. But the interesting thing with law is it's so inefficient and we have such a dearth of metrics. In fact, typically when you make it more efficient by using automation, you're also improving the quality and the costs come down. And that is just unbelievable that you can make all those changes once. If you think about something like document automation as an example, just the fact that you're getting your pronouns right, you're not pulling in the wrong client because you've got it all done in the template system, et cetera, you end up improving the output, right? And it's much faster. So is that?
Very helpful and very important. I mean, I often say that in law, we measure quality almost primarily by inputs. You said that earlier, right? Where you went to law school, you know, how many hours did it take? But that's actually not what people care about. They care about the output. And our output-based metrics have either been totally crude, like do you win or do you lose? But you know, you can win a case and actually not do a very good job and you could have done better, or you can lose a case not because you were a great lawyer, but the facts were bad. Or they're completely subjective, i.e. I know it when I see it. And as I sometimes say, if your best output-based quality metric is associated with Justice Stewart's definition of pornography, it's probably not a good place to be, and yet that is where the legal profession has been. So Ron and others, and in the book, talks about how could you create quality-based metrics. And for some things, that seems very intuitive. But I'm going to come back to you, Sue, to say the more complicated it becomes, or the more factors that we're looking at, not just did you identify the right document, but are you providing something that in the access to justice field that makes people feel heard, or that makes people feel valued, or even in a sophisticated corporate transaction, are you thinking about all of the multiple aspects that go into making a decision? How do you think about the role of technology in those things? And how do we measure or begin to think about quality and the integration of technology in more complex systems?
I guess I'd start with saying, I mean, it's one of those kind of perpetual questions, but I start with saying that technology is the tool, and it's figuring out how you're going to use that tool with its flaws and strengths. And sometimes technology, as Ron was saying, can do a lot better job. I mean, the advanced machine learning models and stuff can look through things. They may have errors, but they can do it much faster and often with much greater accuracy than humans in that context. And sometimes the data sets are just too big. And so I think it's about getting the legal profession to change to think about what's important in those contexts and make sure you're doing that. And it'll differ whether you're talking about an individual and having an access to justice situation and how you can get them so they can have legal documents if you don't have funding for it. That's something where simplified forms for standard tools are really hard to get with some kind of credibility associated with those. And if they can be auto-generated in a way that can provide access, that's really helpful even if they're not perfect. Similarly, if even in a kind of large transaction, if you can figure out how to use the tool, but know that the tool may be biased, know that it may miss certain things, and figure out what you want your legal team to focus on so that they are compensating for that. What it is varies and is situational, but that's what lawyers that we're training in these law firms should be thinking about, not the stuff that could be automated.
So Jason, that's a great place to bring you back in, because I know that part of the challenge of growing Ironclad is exactly the way lawyers are trained to think. And I don't know who trains them to think like this. Who could that possibly be on this panel? But yeah, in a way that emphasizes the uniqueness of what they do, that not even human beings who are not lawyers, who we call non-lawyers, as if they are not actually human beings, but actually some other species, could possibly understand the complexity of what we do. And I know that you've been thinking a lot about how to address that, not just by building, you know, a cool new technology, but really by trying to be a part of a kind of culture change, if you will, around the legal profession. And I wonder if you'd talk a little bit about how you see this and how you're trying to interact with this problem.
Yeah, I mean, we obviously look at this from the perspective of we're a business. Our job is to make a profit and you know, scale our service and our product to as many users as we can. And that provides an interesting lens, because I would say, I'm sure Ron will have something to say about this, but in some ways we don't have the luxury of being able to think about quality. We have to deliver a quality product, but our measures are adoption and revenue and some of these more commercially minded concepts. And I do think that that's provided a powerful lens for us to examine where the industry as a whole is ripe for change. So when we founded Ironclad back in 2014, we looked at a lot of different segments. In fact, one of the first things we considered was selling to law firms. And we sort of scored the different buyers, and we wound up with commercial legal departments where the incentive for change overlapped with the dollars and the speed and pace of innovation that was more of a business pace than a bit more academic that you find in law firm. And so I do think that from this perspective, we are able to see that the change is happening. And it's exciting for me, who's come from the law firm world and is interested in more of the education world, to actually see that start to happen on the ground.
So Andy, this I think is a segue to give you a chance to talk about something you started to talk about, which is it's one thing to try to train law students, but it's another thing to try to figure out how to interface with, you know, the 1,300,000 lawyers just in the United States who are already out there. And how are you thinking about the role that Suffolk can play and is playing in kind of addressing that part of the work?
So in terms of addressing the hundreds of thousands of lawyers who are already out there, when we started talking about our work in law school and we would present on it to bar associations and other groups, I would regularly have lawyers come up to me and say, boy, I wish I had had this training when I was in law school or learned something about it. We got tired of hearing that, so we created a certificate program that was designed to be outward facing, meant for the profession, and not always just lawyers, but other people who are involved, other professionals who are involved in the delivery of legal services, and getting away from that non-lawyer title and recognizing there are a range of professionals now who are involved in legal services delivery and trying to give them some knowledge and skills that would be helpful to them. So that's how we went about it. And of course, by training the next generation of lawyers, we hope that we will be a part of a reimagining of what it is that lawyers do and how legal services are delivered in the future.
So I'm just going to remind the audience both here and online that we will be having time for your questions. I guess what I'm going to ask each of the panelists to reflect on a little bit is what they see coming in the near term, okay? Because a lot of times these discussions either get, you know, they focus on what's happening today, and that's important. And I think already you've heard things that maybe are happening today you weren't aware of, but then oftentimes they venture off into the and one day I'll be a robot or I'll be an avatar and this will all be taking place in the metaverse and, and maybe that is what's going to happen eventually, but there's a lot that happens between now and then. And in some ways that's the most relevant, not just because the students or the practitioners are already going to live in that world, but it's also the nearer term challenges that often get in the way of the longer term transformation. After all, how long have we been saying that the billable hour is dead? Okay, I would say I've been teaching 35 years and it's been said every single one of those years and it's still very, but.
I've never said that.
I know you've never said that. All right, so Ron, maybe you could start us. What do you see coming? What does the book say that's coming in ways that are going to be really impactful for the students in the room, but also for practitioners in the kind of near to midterm?
So it's a tough one. The book is trying to lay out an academic underpinning for some of this and set up the structures that are necessary, both financially as well as philosophically, et cetera. So the chapter that I think that's most relevant to that would be the adaptive innovation.
Yes.
However, which is looking at Christensen's innovator's dilemma to talk about the way that businesses get taken over by the incumbents lose because they're so ossified in the processes that they're going through that they can't pivot when somebody's coming up to challenge them. And I think
Kodak and digital film is the classic example.
well, I think Ironclad or Everlong.
Yeah.
In the legal space, that's happening a lot. But surprisingly, one of the things that I would say is the most pretending to changes in the legal system, in fact, is one of the most potentially boring chapters, which is around standards. So the chapter in there about XML and the way that we codify documents, court decisions, contracts, whatever, patents, so that we can actually pull the data out of those structures very easily and then distribute that around and have everybody looking at the same data. I can't tell you how many startups are sitting there looking at court opinions and reprocessing the stuff, which you wouldn't have to do if you just tagged it in the beginning. But we don't have a set of standards in terms of what court opinions should do and how they should tag that up. Another thing that you would look for, which is common, I think Kara would know quite well, is the acquisition of the data, which is a leading indicator. It takes anywhere from 3 to 5 years for law firms or in-house to get their ducks in a row in terms of really getting a handle on what's being spent on what, how do we set up our building code so we know, like there's different types of deposition. You can't do anything if you're comparing somebody who witnessed something compared to an expert witness compared to the head of a company. So you need to, the building codes don't really have that in there. Well, once you start getting that data, you start being able to assess what are the best processes to use, what's the best way to get efficiency. So that data is increasingly being gathered. And once you have that data around, it will be used. So the machine learning that we're talking about, you can't do anything. And people, trying to look at bankruptcy filings. Well, okay, it all has to be structured in a certain way so we can go after all of that stuff. And that's happening. So, 5-ish years, 10-ish years, like that's going to kind of explode.
There's a tipping point, right? The more we get the data, the more we get it in a usable form. Jason, I mean, is that also kind of what you're seeing? And where do you see what things are going to affect the lives of these students who are graduating this year in the next 5 years?
Yeah, I mean, I agree with Ron's point that we are approaching the tipping point and the pace of change will increase over the next few years for sure. I'd say I'll two quick predictions. I think law firms are going to start to differentiate their offering by using technology. One of the reasons why it's been terrible to work for a law firm is law firms don't have a lot to differentiate on, and they differentiate on responsiveness. And that doesn't create a good working environment if your only way to differentiate is how fast you respond to email or how fast you turn something around. Technology is a way for law firms to differentiate their offering, and I think we'll see more of it. We can already see the beginnings of it just in the contract space. And I also think in the corporate world, the role of the legal department and the general counsel is having a resurgence that will increase in pace over the next few years. The legal department has generally been on a downward trend and become more of a back office function over the past couple of decades, and technology gives the legal department something that they can give back to the rest of the organization, which is data. And data is the new oil, and the legal department has a ton of interesting data in their contracts. So being able to access and control that data is going to create more power for legal departments in the corporate world.
So for those of you interested in this, you could go to the Center on the Legal Professions website. We've done a series of empirical research projects for many years, but really for this purpose since 2021, and then another one that we just completed in 2022, very much about the new role of the legal department is playing in a whole range of areas. Yeah, Ron.
Let me just add, because I'm always looking to see how this goes across the legal system. Data is their legal Zoom, for example, is going to be collecting data on everybody's, corporate filings or whatever. You're going to see other data being collected like Clio or my case, where lawyers, small, mid-size, are online in these platforms. So we're going to see this data starting to get aggregated, but across the legal system.
And in some ways, Ron, I think is a really critical point. It's more impactful for small firm and solo practitioners and smaller providers or public interest organizations, precisely because they don't have the resources that the larger institutions have to kind of, get by without the data. I mean, they can't, and they also, their own data isn't good enough. They need to aggregate it across a range of similar kinds of providers for it to have the power you're talking about. So it's a really important point. Sue, predict, prognosticate.
Yeah, exactly.
That's
So,
your new job.
I
You
know,
that's
I
what
was
we
gonna say,
do.
with respect to this, now that I'm at Berkman, I have to take it a little bit further. But stepping to the law firm role for a bit, I think that the commoditization and standardization of the things that can be is happening, and you're gonna see that increasingly. As well as advanced data analytics and figuring out how to use advanced data analytics in your practice. Like if you're working with a particular judge, you're gonna wanna have some models kind of play around and look at all the different decisions that judge has had. You're gonna want to.
Unless you're in France, in which case they help on it.
Yeah.
Exactly. And so figuring out how those sets and what kind of ethical frameworks are gonna come in to look at this, which was what I was gonna say next, was that it is, trying to think about what these mean when you start to have decision-making that's dependent on analytics and databases, and how you play around, where you draw the lines with respect to this, when, we would even play around with some of the advanced models and see what you could generate through them and how much the voices are going to reflect what's there. So I see a lot of these tools starting to come in, as well as creativity. It was really fun to see some players that would kind of put out there an app to try to create a new interface for how you were going to kind of access clients. And just, I think being creative with respect to legal innovation is going to be really important.
So I think that's right, but you also mentioned something that I know, Andy, you also think about, which is not just how do you prepare students for this, but what are the ethics and norms of this?
Yeah.
Oh, you teed it up perfect. That's exactly where I was gonna go with my
I thought
answer.
it might be.
But before I offer that answer, I will add a note of caution. I'm a big fan of a quote from a baseball great Yogi Berra, who once said, predictions are difficult, especially about the future.
Yeah.
So I always offer predictions with a heavy dose of salt. But I do think one very important development that's going to change the way legal services are being delivered is in the area of regulation. We are seeing notable regulatory innovations in particular states. If you haven't seen what's going on in places like Arizona and Utah, it's really worth checking out. They are unlocking the potential for new kinds of legal services delivery models and providers. Historically, for those of you who have taken legal ethics recently or are ethics wonks like David and I are, you'll know about Rule 5.4, which has for a very long time, with very limited exceptions, prevented lawyers from partnering with anyone who is not a lawyer in the delivery of legal services and sharing fees. Those kinds of restrictions and prohibitions are slowly but very concretely starting to change. As lawyers are allowed to partner with other kinds of legal professionals, you are going to see new delivery models, new kinds of professionals joining traditional practices, and we are going to see, I think, a sea change in the legal services delivery model, which comes back to the overarching point that I mentioned in terms of legal education, why it is so important for students to be aware of all of these developments, because I think the marketplace that you are going to find in your career is going to be markedly different from the one you see now, in no small part because of technology, innovation, and data, but regulatory change as well.
Terrific. So those are good predictions. We'll see if they come true, but we have actually, I told you, an amazing audience, over 300 people all around the world, lots of different spaces in this industry, and our own Dana Walters is going to read us a question from the audience for our panel.
Thank you, David. I'm actually going to read you 3, and then you all can pick and choose what you respond to. I want to start with a question from a judge in India, asking about the cost of technology and that it is often very expensive. So if anyone could speak to how costs play into these issues, both from the access to justice side as well as the more corporate side. Question number 2, data plays a role in well-being, not just the delivery of legal services, but how law firms are managing their employees, for instance. Wondering how you all think about that aspect. And then the last question, what is the role of blockchain in these issues? And sort of on the other side of that, what should lawyers know about cybersecurity?
So I told you we had a great audience. Those are amazing questions. I don't know, Jason, you want to start with the cost question? Because that was one I assume you're wrestling with all the time. And, you know, I wonder, for example, is it like in lots of other things where my phone gets better and better and cheaper every year? But it still manages to cost $1,000 in my Verizon plan, but I'm not griping. But anyway, how do you think about the cost of technology and how it factors into this?
Yeah, I mean, I can provide one data point, which is our industry. It's called contract lifecycle management, is the historical term. And contract lifecycle management has historically been a very expensive piece of software. So it was a database, and back in the day it was Oracle and SAP. They sold you a database with some contract fields, and you needed to figure out how to get your contracts in that database. And the best way to do that, what the best companies in the world did, is they hired teams of people called contract managers and administrators, and they went out and found all the contracts that this company was making, and they did data entry into the database. That's extremely expensive, and the cost of maintaining that system was in the tens of millions of dollars a year. So only the biggest companies in the world could really access contract lifecycle management. The cost has come down dramatically. We're not there yet, but contract management is something that every company in the world should want to do. Everyone wants to make contracts faster and access the information in them. So there's a huge gap from the Fortune 500 who was previously able to access this to the current state of the world, which is, you know, I would say like corporations above 100 people. We've certainly addressed a lot more of the market, but there is a much longer tail. And I do think that cost and that ease of use will continue to come down over time.
So Sue, maybe I'd like you to reflect on this too, because you mentioned an example of the human rights organization you're working at, or another startup that a wonderful young woman called, I'm blanking on the name of her startup, but it's around trying to get access to public defenders to CCTV footage the same way that prosecutors have access to that, because it's become so important for criminal cases. But a big barrier in all of this is cost. And so I wonder, how are you guys thinking about that?
Yeah, I would say the challenge is real, and hopefully we can drive dollars towards some open source solutions for this. Cover your ears, sorry. It keeps part of the market niche, but I think so that you can address these, figuring out how you can put these tools in the hand of civil society as well as in the hands of a global network of people who don't have the resources for this. So it's not just in the large firms. And it's one of the things that's hard. That's not where dollars are always driven to, but it's really, really important because those tools, you're going to see them on one side of these cases, whether it's from, if you pick the case of that one, whether it's the police forces that would have the tools, and how do you figure out how to have individuals have those tools as well. It's gonna be an ongoing challenge though, because building these kind of tools is really expensive. It requires a lot of investment, and to do them well.
So I'll just, Ron, I see your hand up there. I'll just say, because I remember the name of the company is called Justice Text, and I want to plug it because it's really innovative. And but let's also not forget lawyers are really expensive too.
Right.
And one of the big problems in access to justice is that some people have expensive lawyers and some people don't. But Ron, did you want to?
Yeah, there are a couple of points. Open source is one thing, but open standards is probably the better way to go. And I mentioned that, again, the role of standards here is crucial. And so when you have certain types of data that anybody can process and hand back and forth, then everybody's free to compete on the cost and the utility, and people can then decide what level they want to purchase. In terms of the cost factor that somebody asked about, LegalZoom is looking for that latent market of people that have some money to pay, right? Not legal aid, where there's basically no money, and not high-end corporate. And Everlaw as e-discovery, where we're leveling the playing field here, because the cost has just come down so much that that's not the deciding factor for whether or not you can pursue litigation. So as soon as you bring the cost low enough, it's no longer the driving factor as to what decisions you might want to make, and that's all you need. And so, of course, the cost being low enough is going to be different for a large corporation as it is for an individual. But the goal there is the same, which is not to do it necessarily for free, but to bring the cost down so that it's no longer prohibitive and it's a value proposition. And so by somebody from India saying we don't have the technology is not available to us at a cost point that is available, we can't afford that. I think, keep watching this space, because Everlaw is an e-discovery platform, cloud-based, their whole thing, the whole new model was low margin work, a totally different billing model. That's becoming increasingly affordable for smaller levels of litigation, right? And that's just going to be across the board, I believe.
So Andy, I'm going to ask you actually to pivot to the question I know you also have thought a lot about, which is the relationship between technology and wellness. We've all just gone through 2 years of online Zoom. And I remember asking a friend who's a lawyer, I said, what's it like working from home? She said, I'm not working from home, I'm sleeping at work. And I think we've all had that feeling of what that is like. And there is profound effects on wellness. And as a law school dean, I know that's something you're thinking about. So talk a little bit about that aspect.
Boy, we could take a whole hour, I think, on that question. Technology is a double-edged sword, I think, when it comes to wellness. On the one hand, it really enabled us to survive the pandemic, engage in our work in ways that ultimately benefited us and the public that we serve. On the other hand, by sleeping at work, we really have made life a lot more difficult for us. I'm getting serenaded I hear with some.
Yeah, is that
not me? Is it?
Sorry.
Sorry.
This is part of our wellness.
This is part of- yeah, I was saying
that. I'm talking about wellness. I'm getting very
Sorry.
in the background. I thought it was imagining it.
I have my phone on silent, and for some reason
It was actually perfectly timed.
It was very sound-like.
Yeah, it did. I felt like a message. It was good. It was good. So I think technology really, if used well, can be a tool in support of our wellness, but if used poorly can undermine it. There's another aspect to wellness, which is the public's wellness when it comes to the services that they need. It's not exactly the question that you were asking, but I think it's an important one. The more that we can use technology to address the public's legal issues, the better off people will be found, at a fundamental existential level when they are facing an eviction from their homes. And we can put a tool in their hands that enables them to address that issue without being able to hire a lawyer where they might not be able to afford one. And they are in a state where it doesn't provide one as a matter of right. that is a fundamental question of wellness in a very real way. So I do think that there are senses in which technology can drive wellness, both for the public as a whole and individually as professionals, but we need to do it wisely.
So Jason, I'm going to ask you to comment on the last question, because my guess is the more we put our documents in the cloud or online, the more we tie everything up with AI and machine learning, the more vulnerable we are at some level to cybersecurity, hacking, data crashing threats. You know, I have to say, I always, when I go to get my electronic boarding pass, I always take a picture of it so that in case I can't get internet in the airport, I can actually show the thing, right? So how are you approaching this intersection between cybersecurity and this increased drive towards technology?
I think it's a really important question. I think it's one that will become increasingly commonly addressed in our industry and brought up and talked about. Because we are different than a lot of technology verticals in that we're dealing with really important stuff. And just as that's going to power the resurgence of the general counsel and the legal team because they have access to it, it also creates a risk because once it is in a system, it can be accessed and it can be hacked and it can be used in all sorts of nefarious ways. So I think it's really important, and I think it needs to impact the way that legal technology companies approach security and compliance from the early days. This is not a, Facebook move fast and break things. We cannot take lightly the responsibility that clients give technology companies when they hand over the most important documents. So, I mean, it's something we thought a lot about, and I know a lot of other technology companies have thought about, but it cannot be underestimated.
Yeah, I really have to point out here that medical informatics has dealt with this for a long time. Not just in terms of privacy, but there are reference implementations of various aspects of a medical record, et cetera. And we have government agencies working on this, like NIST, which is Standards in Technology, the National Institute of Standards and Technology, and we need the equivalent in law.
Which goes back to, I think, Andy's point about regulation, right? That this whole area is also going to be the subject of increased regulation, which of course, for the lawyers in the room, will also drive demand for legal services, which will also then create the feedback loop. Listen, this has been an amazing conversation, and you see we can just scratch the surface of these issues. I'm going to ask Ron if you have any kind of words in closing about, you started us on this journey, you worked hard on this book. It was an incredible effort assembling this really blue chip group of authors from such a wide range of fields. And I wonder, any words you want to leave our audience online and our audience in the room about this important topic?
I should have
In
been
30
prepared
seconds
for
or
this
less.
question. I think it's mainly about the inevitability of this and that you don't have to know how to build a car to know how to drive a car. And the more you know about the car, the less likely you're going to get screwed when you go to the mechanic. And so, just having a basic technological underpinning background of the application of technology to law and these kind of academic underpinnings are very helpful.
Well, if you want that, product placement, one last time, go out and buy this book in all seriousness. And it's written, here's one thing also I will say, it's written to be read by ordinary people, by lawyers. There are sophisticated things for people who are more sophisticated about it, but it is not written that you have to be like Ron and have a PhD in search, or I think that's what your PhD is in order to read it. So thank you all for spending this time with us. Thanks to our folks online, for all of you here. And I hope this is a conversation that we can continue at the Center on the Legal Profession and here at Harvard Law School. And for those of you in the room, our audience here can stay a few minutes if you have questions. Thank you all very much. Please give them a round of applause. Thank you.